So, friends, we have not one, but two new court filings in Donald Trump's federal election subversion case in Washington, D.C. The first filing is a new court order by Judge Chutkan in which she denies Donald Trump's request to send special counsel Jack Smith off on a snipe hunt. More about that in a minute. And in the second court filing, it is Jack Smith filing a 9-page motion responding to some claims that Donald Trump's lawyers made and setting out, once again, precisely why Donald Trump is criminally responsible for trying to steal the 2020 presidential election. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, today we're going to cover two new court filings in Donald Trump's federal prosecution in D.C. for trying to steal the 2020 presidential election, and we're going to do it really for the sake of completeness. The first is a new court order by Judge Chutkan on a discovery issue. That is, what information and evidence does the prosecution have to give over to the defense in discovery? And this motion filed by Donald Trump's lawyers is a beauty because, in essence, they were trying to get Judge Chutkan to send special counsel Jack Smith off on a snipe hunt. You all know what a snipe hunt is? It is where you try to fool somebody into going out and hunting for an animal that doesn't exist. A snipe, hence the term snipe hunt. And Donald Trump's lawyers filed a discovery motion demanding that Judge Chutkan order Jack Smith to search, quote, 9 government agencies for 14 categories of information that we're entitled to. And Judge Chutkan just issued her 50-page order saying summarily, nope. But she did say, I will ask Jack Smith to make some inquiries on 3 discrete possible pieces of information. And I'm sure Jack Smith has probably already done that or is in the process of doing it promptly. Here's the new reporting on Judge Chutkan ruling, nope, taking 50 pages to do it. This from CBS News. Headline, Judge in 2020 election case mostly denies Trump's demand for more evidence from prosecutors. And that article begins, the federal judge overseeing the 2020 election case against former President Donald Trump largely rejected Wednesday Trump's demand for prosecutors to search for and turn over more information that the former president believed would support his defense and show his state of mind as he contested the results of the last presidential contest. The 50-page order from U.S. District Judge Tanya Chutkan came in response to Trump's request to force special counsel Jack Smith and his team to search 9 government entities for 14 categories of information and hand the evidence over to his legal team. But after reviewing the tranches of material sought by Trump, Chutkan found that prosecutors should conduct a search for just 3 types of information and produce to the defense what they find. Those batches include material the Director of National Intelligence reviewed before an interview with the special counsel's team, records regarding security measures that were discussed with Trump during a meeting with former acting Defense Secretary Chris Miller and Chairman of the Joint Chiefs of Staff, General Mark Milley, days before the Capitol attack on January 6, 2021, and evidence related to the federal investigation into Vice President Mike Pence's handling of classified records after leaving office. So, friends, like I said, Judge Chutkan, in substance, ruled nope, with 3 minor exceptions. Okay, let's turn to the second court filing today, and it was a motion that was filed by Jack Smith. It was actually in opposition to Donald Trump's motion to dismiss, and this issue is kind of down in the legal weeds, so I'm going to try to keep it simple. Lots of the people who went to the Capitol, stormed the Capitol, attacked the Capitol, and tried to stop the certification of Joe Biden's election win on January 6th, 2021, what I call the boots of the insurrection, the people who were following Donald Trump's orders to go to the Capitol, fight like hell, or you won't have a country anymore, now go stop the certification, stop the steal, and they did. Those people were charged with several crimes, depending on what they did, and among those crimes was obstructing Congress, obstructing a congressional proceeding, the certification of the results of a presidential election. That's exactly what they did. And here's the law that they were charged under, and then we're going to talk about how the Supreme Court, the radical right-wing bloc of the Supreme Court, threw out all of these convictions against the boots of the insurrection for, when they were convicted of or pleaded guilty to obstructing the congressional proceeding by storming the Capitol and stopping the certification. Here's the law that they were prosecuted under. For anybody scoring at home, it's 18 United States Code, Section 1512C2. And here is what that federal law provides. This is what the boots of the insurrection did and were convicted of. Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official congressional proceeding, or whoever corruptly otherwise obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title or imprisoned not more than 20 years or both. And friends, that's exactly what the boots of the insurrection tried to do. Many of them, they tried to obstruct, influence, or impede the official proceeding, the certification of Joe Biden's election win. But the radical right wing of the Supreme Court didn't like that. They didn't like the express text of the law. So they said, no, the law doesn't really mean what it says. And they said what 1512C2 is really getting at is when somebody messes with an official document or a record, and uses documents or records or fake evidence to obstruct a congressional proceeding. Well, folks, that's not what the law says, and I thought y'all were textualists. Please, they're ideologues, friends, and we know it. Discussion for another day. But they said in the Fischer case, that's the name of the case, nope, anybody who attacked the Capitol and tried to stop the certification, even though they obviously tried to corruptly impede it, is not guilty of that crime. We're throwing them all out. So what Donald Trump did was he said, well, then you got to throw out all of these charges preemptively against me, even though I haven't been tried yet, because of the Fischer case, Well, Jack Smith just filed his reply saying, look, sport. Okay, he didn't call Donald Trump sport. I did. Look, sport, what you did when you obstructed and impeded the certification of Joe Biden's election win, trying to corruptly retain the power of presidency for yourself, involved documents, among other things. You were the head of a conspiracy by which fake elector certificates were generated, were sworn to, under the penalties of perjury, even though they were fraudulent, were signed by fake electors, were sent through the mails, that's mail fraud, to the Senate and to the National Archives to be used by Mike Pence. That was the scheme to interfere, to obstruct, to impede that official proceeding. So even under Fischer's rationale, sport, you lose. Your motion to dismiss should be, must be, will be denied. That's the motion, the 9-page motion that Jack Smith just filed. So friends, let's finish up by reading the opening salvo of Jack Smith's brand new 9-page court filing. United States of America versus Donald Trump, defendant. Government's response in opposition to the defendant's supplement to his motion to dismiss on statutory grounds. The defendant's new arguments in his supplemental brief fail to bolster his case for dismissal. He principally argues that the Supreme Court's decision in Fischer versus United States undermines counts 2 and 3 of the superseding indictment, which charged the defendant with conspiring, obstructing, and attempting to obstruct the congressional proceeding on January 6, 2021. But Fischer did not invalidate Section 1512 or elevate basic pleading requirements, and the defendant, Trump, fails to identify any pleading flaw in the superseding indictment warranting its dismissal. Moreover, the defendant's motion ignores entirely that the evidence against him includes allegations that he and his co-conspirators sought to create and use false evidence, fraudulent electoral certificates, as a means of obstructing the certification proceeding, which Fischer expressly held falls within Section 1512(c)(2). Finally, the defendant's half-hearted arguments against counts 1, conspiracy to defraud the United States, and 4, conspiracy to violate civil rights. Violate civil rights. Our rights. Voting rights. Donald Trump's conspiracy to deprive us of our votes. That wasn't Jack, that was my editorial edition. The defendant's half-hearted arguments against counts 1 and 4 likewise lack merit. The defendant's statutory motion to dismiss, as supplemented, should be denied. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.